Hi, my name is Gabriel Gonzalez. Um, in today's lecture, we're going to talk about the differences between a will versus a trust. Okay? And just to get some disclaimers out of the way, I am not a licensed attorney. I am not licensed to give any type of legal advice. This video should not be construed as legal advice in any way, shape, or form. The purpose of this video is nothing more than for information and educational purposes only. If you're looking to do any type of elder law planning or estate planning, I strongly recommend please speak to a licensed elder law attorney in your area of jurisdiction. Okay, without further ado, let's segue into our lecture. Wills versus trusts. So as I mentioned in one of my previous videos, when it comes to estate planning, elder law planning, um, essentially planning on what's going to happen after you pass on is a very, very important thing. Okay? Why? Because of control. You worked very hard for your assets. You worked hard to build what you have built, but you want to be able to have a plan in place in order to transfer those assets to who you want, how you want, um, how you want, and when you want, with as least legal fees and taxes possible. So you have to have a plan in place, okay? Because no plan is just a plan for disaster, and you don't want to do that, okay? But believe it or not, if you happen to be one of those few that like to procrastinate, and you kicked the bucket and then you didn't realize you didn't really have a plan in place, the state of New York, where I live, as true in many other states, have a plan written for you. That plan is what's called the intestate succession laws. The word intestate is a word meaning that you've died without a will or a trust, versus the opposite, where if you've died with a will or a trust, you have said to have died testate. Okay? So, EPTL stands for Estates, Powers, and Trust Law. Estates, Powers, and Trust Law govern in the state of New York the rules relating to wills and trusts. Okay? So, under EPTL 4.1.1, that highlights the intestate succession laws. That basically gives the surrogate courts instructions on how to transfer those assets to, however the law dictates. The key problem with that is control. Okay? Perhaps you don't want certain assets to go to certain people. If you don't have a plan in place, and you don't have, let's say, a will to give, which is a set of instructions to tell the surrogate court on how you want those assets to be distributed, what other guideline does the surrogate court have? They have no choice but to default to the intestate succession laws. So it's very important in place that in order to be able to maintain control, you have to have a plan in place. So if you look in our toolbox, we have available two plans, a will versus a trust. Okay? Now, at the end of the video, I'm going to tell you what I feel is my preference, just based on my understanding of elder law and estate planning. Some people out there may have a difference of opinion. I feel that a lot of attorneys would agree with where my thought process is going for the reasons I've mentioned. Okay? So let's discuss what a will is. So as I mentioned a moment ago, a will is a set of instructions that gives the surrogate court. The surrogate court is the court that deals with the administration of an estate, especially that involves wills. And in a subsequent video, I'm also going to discuss that it also deals with the handling of guardianship proceedings. Okay? So what is the legal process that the surrogate court goes through in order to handle the administration of a will or handling guardianship proceedings? That legal proceeding is called probate. Okay? So when that person dies and that person has a will written, it's not something as simple as, oh, you know what? I have a will. The will says I get this, my siblings get this, and this other person gets that. It just doesn't work that way. You have to go through the legal proceeding of probate. So what do you have to do? Well, first, if you have a will, you have to go down to the surrogate's court and file a petition of probate. Then any interested parties that are involved in that's involved in that will have to be notified. So one key thing about wills is, as I mentioned, you have to deal with probate. The other aspect of will is that it's public record. Okay? So because the will has to be filed by the county clerk's office, and now it's being submitted to the surrogate's court. What's stopping someone to going down to the courthouse, pulling up your will, and seeing, ooh, this is the amount of assets they had. Ooh, this is the people that are going to get it. Oh, I was left out of the will. What's stopping them from doing that? Well, if you have a will in place, that's public record, okay? And what's stopping that person from disputing that will? That gets into the area of what's called probate litigation, okay? So another component of will is that it's public record, okay? Now, in New York, in order to probate a will, at minimum, that will has to be open for at least 6 months. Reason for that is to give creditors an opportunity in order to go down and get claims of the estate, okay? But at minimum, it has to be open for 6 months. Sometimes these wills are left open for years, depending on how complicated the circumstances, depending upon if you have a family member that wants to litigate the will. Some of these things can last a long time. And what is the big problem with that? Money, okay? So by you going down to the lawyer's office, spending maybe a few $100s, I mean, I'm not sure what the going rate for a will is, but I'm sure it's a lot more inexpensive than a trust. By spending a few $100s for that will, it now costed you a whole bunch of more money down the road because now your assets are tied into probate. So now you got to get an attorney. You got to pay legal fees. You got to pay court fees. You got to go through all that headache. The other thing when it comes to probating of the will is what's called accounting. You have to submit an annual accounting of all of the assets. Money that went in, money that went out. It is a process and a half, okay? So when it comes to wills, you have to also do an annual accounting, okay? Now, as I mentioned a moment ago, the process in order to probate a will is you have to file a petition for probate. Then you have to give waivers to interested parties, and they have to sign those waivers saying that I'm not going to dispute the will, I have no issue, and that's that. But what if you have a family member that wants to dispute the will? Hey, I didn't get my rightful share. Hey, I was left out of the will. I don't want to sign the waiver. Now you got to go back to the surrogate's court, and the surrogate's court has to issue what's called letters of citation, which now requires them by law to go down to the surrogate's court, and the judge is going to ask him, why didn't you sign this? He may not agree to the terms of the will. He might say, well, you know what? I think I was left out because person A had an influence on person B, and that influence left me out of that will. So there could have been an undue influence, okay? Some type of personal relationship that had an influence in keeping me out of the will, okay? Maybe there was duress. Maybe behind closed doors, person A said, if you put person C, me, in that will, I'm going to kick your butt. Maybe there's been duress. So basically, my thing is, if I'm not left in the will, and I want to dispute that will under the grounds of undue influence, duress, or whatever legal remedies that I have, okay, I may end up disputing that will and saying, well, wait a second, I don't think that will was executed in accordance to all the laws in the state of New York, and I want to invalidate that will. Now, why would I do something like that? Well, under the current situation and circumstance, if I'm dealing with that will and that I'm left out of that will, maybe if the judge says, okay, that will is invalidated for so-and-so reason, maybe under the intestate succession laws, I probably would have gotten something. See, that's the problem that you have to deal with a will. Because you have to do with probate, because the will is public document, you now open yourself up to a whole slew of possible conundrums. Now, it may just work out very cleanly that, you know what, I may not have to, dispute the will. I have no issues, and everything's home free. But like I said in my other videos, there's no such thing as a one-size-fits-all plan. There's no, you got to anticipate every situation and circumstance. So time is money. Tying your assets into probate is going to cost you a lot of legal fees, court fees. You got to deal with issues of family members that may have been left out, the possibility of probate litigation, that's a problem. Okay? So I think that's a big, big issue. Now, the other thing with regards to a will is what? If you guys been paying close attention, what's also another component of a will? It takes place after you die. Okay? It takes place after you die. Okay? So it's not a living, breathable document. What is the problem with that? Well, more and more people, especially as they're getting older, are prone to disability. Believe it or not, people today are living much more longer than they did maybe 30 years ago. People are living on an average maybe 20, 30 years much longer. And people are more prone to being disabled the older they get. Okay? So what's a problem with a will is it takes place after you die. Okay? It's not a living, breathable document. The other problem with a will is this. Disability. There's no plan for disability. Because the will takes effect after you die, there's no plan for disability. So if you all of a sudden cannot handle your own financial affairs, and you don't have a power of attorney in place, as an example, or a trust, then what happens? Well, if the court, then you got to go down to the probate court. And now the probate court is going to determine and assess that you cannot handle your own financial affairs. What is that legal proceeding called? Well, if you don't have a plan in place, like I mentioned, either a power of attorney or a trust, the state of New York wrote a plan for you in terms of disability. That plan is called guardianship proceedings. So what ends up happening is that the court appoints a legal guardian, okay, and in most cases it's going to be some type of outside attorney, okay, in order to handle your own financial affairs. Now, let's say you weren't disabled for that moment in time. Who do you really want in charge to handle your own financial affairs? Some stranger attorney that you've never met in your life? Of course not. Most people would probably say their own adult kids. Well, if you don't have a plan in place for disability, and the will obviously is not a plan for disability, guardianship proceedings are up your alley. So here you are, you're 80, 90 years old, you can't handle your own financial affairs. The surrogates court appoints a legal guardian, which is usually an attorney, and that attorney is handling your financial affairs. Again, you lost all control. Now, you can get that control back, but it's not as simple as you think it is. Okay? You now have to go back to the probate court. You have to go back to the surrogates court. You have to go through another probate proceeding, the guardianship proceeding, I should say, and you have to prove to the judge that you are mentally competent and you can handle your own financial affairs. Now imagine you're 80, 90 years old having to be going into the court and asking for the judge for control of your assets back. It's not a happy place to be in. So having a plan in place avoids all of these things, okay? Because no plan is a plan for failure, and it's a plan for disaster, and that is not good, okay? So that's one of the other drawbacks when it comes to a will, okay? So again, just to kind of recap and highlight with regards to wills. A will definitely gives the court a set of instructions on how you want your assets to be dispersed so that you don't have to fall under intestate succession laws. But as I mentioned a moment ago, there's a lot of drawbacks to wills. Again, probate, disability, okay, there's no plan for disability, which means you have to deal with guardianship proceedings, okay? So, what is the alternative to a will? Okay, what can we do? Well, this is where we enter the wonderful world of trusts. Okay? So what is a trust? Okay, I'm just going to erase this. Well, a trust does achieve the same aspects of a will. Similarly, and let me explain how. It's a plan. Let me kind of backtrack. A trust is definitely a plan in terms of how you want to transfer your assets to whom you want, how you want, and when you want. However, that's the similarity. The big difference is control. So for those that don't know what a trust is, and this is my poor example of a triangle. Listen, I wasn't an art major, so forgive me on this, okay? I'm going to draw a triangle here. So a trust has three components. There's three parties to a trust. The first one is the individual who writes the trust. That is your grantor. The next person that you have is the trustee. Lastly is the beneficiaries. Okay? So you have the grantor, the trustee, and the beneficiary. Okay? Three parties to a trust. What part does each part play? All right. A grantor is the one who creates the trust. Okay? He's the one that creates a trust. And basically, in a nutshell, a trust is an agreement between three parties that allows the assets to be transferred to whom you want, how you want, when you want. The grantor is the one that creates the trust and that actually puts their assets into that trust in order to have that asset transferred, to the intended beneficiary. The beneficiary is the one who's going to benefit from the assets of the trust. Okay? The trustee is the third party that acts in a fiduciary capacity. A fiduciary capacity means that they have to act in the best interest of the grantor, and their main responsibility is to manage that trust. Okay? So the goal is to get the assets from the grantor to the beneficiary. The trustee is the one that's going to assist in the transfer of those assets to the beneficiary after the grantor passes away. Okay? So that in itself is what a trust is. Doesn't the will work the same way too? So when you have a will, it also involves three parties. You have the testor or the testatrix, depending on if it's a male or female. You have the executor, and you have the beneficiaries. Same three-party transaction. The only difference is that with the will, it takes effect after you die. So once it's proven that the will is valid, at that point in time, the executor gets appointed. Now, the legal document that appoints that executor is what's called letters of testimony. Letters of testimony basically empowers the trustee to now transfer the assets to the beneficiary, okay, by the permission of the court, based on the testor's wishes. Again, it takes place after you die. The trust is a living, breathable document. As a matter of fact, in a trust situation, you probably have heard the term living, revocable trust. Now, we're also going to talk about what an irrevocable trust is shortly, but I want to segue into what a living, revocable trust is. The key thing in here is the word living. Living. It's a living, breathable document. So when do you think the trust takes effect? After you die like a will? No, it takes effect while you're alive. Okay? Now, what does the word revocable mean? Revocable means that you can change it. You could change it whenever you want it. You could change beneficiaries. You can pull assets out. You can change it. Okay? That's what a revocable trust is. Now, what are some of the benefits of a living revocable trust? Well, one of the benefits of a living revocable trust is something called Probate avoidance. Probate avoidance. By you having a trust, you'll avoid probate altogether. Instead of having to file a petition for probate for a will, and having to prove to the court that that will is the original will that's been valid, has followed all the legal formalities of executing that will, you'll avoid all that altogether, which saves both time and money. Probate avoidance. The next big benefit of a living revocable trust is that it's a plan for disability. Now, the nice thing about a living revocable trust is that while in spite the fact that the living revocable trust takes effect while you're alive, one nice thing about the living trust is that you don't have to appoint someone else to be the trustee. It's not recommended, but you can also be your own trustee. Again, it's not recommended, okay? If you decide to be your own trustee, it's recommended that you have a backup trustee, a co-trustee, okay? In the event that you become disabled, because at that point in time, after you pass away or you're disabled, you can't act on yourself. So you can be your own trustee, but it's recommended that you have a backup trustee. In the state of New York, if you have a living revocable trust and you have a trustee other than yourself, or if you are a trustee but you appoint a backup trustee, under the laws of the state of New York, you don't have to go through a guardianship proceeding. Because who's going to ultimately be your trustee? If I was the parent and I wanted to transfer my assets to my children, who do you think I may want as my trustee? I may have one of my adult children to be a trustee. So now this goes back to control, okay? I have now control in terms of who I want to appoint in the unfortunate event that I become disabled, okay? So according to the laws of the state of New York, if I have a living trust and I have someone else other than myself as the trustee, or I have a backup trustee, a co-trustee, I have now a plan for disability, and I've essentially avoided guardianship proceedings. The court cannot appoint a legal guardian in order to handle my affairs. So I avoided guardianship proceedings. So by spending a little more extra money up front and actually getting the right tools, I now saved a whole slew of headaches and a whole slew of money problems down the road. Okay? There's an old saying, and I hate to use it in this situation, but it's very true. You do get what you pay for. If you're going to try to go the least inexpensive route, and again, I'm not trying to put down those that want to use a will. Maybe that's all they can afford. But in my own personal opinion, I think wills are obsolete, because while the will is a set of instructions that give the surrogate court a set of instructions to the surrogate court on how you want your assets distributed, that's pretty much its only use and benefit. There's more drawbacks to a will than there is a trust. And maybe wills, they were very good hundreds and hundreds of years ago. In this day and age, as things have changed, as people are living much longer, there's a lot more drawbacks to a will than there is a trust. So if you ask my own personal opinion in terms of an estate planning tool, and I think a lot of lawyers would agree on this, a trust is your better alternative. Absolutely, because a trust gives you control. And yes, perhaps you may have to spend $1,000 or $2,000 on a trust. I don't know what the going rate is for a living revocable trust. Okay? But at that $1,000 or $2,000 is going to be money well spent, because you'll avoid probate proceedings, you'll have a plan in the event that you become disabled, so you'll avoid guardianship proceedings, and you'll have control. Okay? So that's pretty much the difference between a will and a trust. I think I've gone a little bit more in terms of my time, in terms of how I want to elaborate all this, but I kind of wanted you guys to have the gist as far as what's going on, and sort of have a good understanding on that. And hopefully I've given you guys a good understanding, good comparison between a will and a trust. Thank you.